Let me move now to the subject of discovery and production of documents in U.S. litigation that happen to be in the possession of foreign parties and foreign affiliates. I think the U.S. Discovery system is probably very well known and for good reasons feared around the world. It can be very expensive and extremely burdensome, and it's often a very important issue as to under what circumstances a foreign company that's involved in U.S. litigation can be required to bring documents and data, especially these days, electronic data and electronic evidence, to the U.S. For production in proceedings. If a foreign company is a party to U.S. litigation, either because it's a plaintiff and has filed the claim, or it's a defendant, it's been sued, and the court has personal jurisdiction over the defendant. If a foreign company is a party to the litigation, the defendant is, the foreign company will be subject to the full scope of U.S. discovery rules under the federal rules of civil procedure, subject to the same extent as a domestic company would be. And at least as far as the U.S. courts are concerned, this is not limited by international treaties, for example, the U.S.-Japan Bilateral Consular Convention or the Hague Convention on Taking Evidence Abroad. A foreign party which is a party to U.S. litigation can be required, just like a domestic company, to collect documents and produce them in the U.S. And the question then becomes, how about documents that are, suppose the defendant, for example, or the plaintiff, is a subsidiary of a foreign corporation. Can that subsidiary be required to get documents from its parent company, which is headquartered abroad and is not in the U.S., or from affiliated companies within its corporate structure and produce them in litigation in the U.S.? The general test here is that if documents are in the possession, custody, or control of the defendant, they must be produced. So it comes down to the question of, does the party to the U.S. litigation, for example, a subsidiary, have possession, custody, or control of documents which are abroad and are in the possession of its corporate affiliate? And this often, again, gets down to a factual determination as to whether, in practice, the party to the litigation has access to these documents and could get them if they, for example, needed them or used them in the ordinary course of business. So courts tend to look to what is actually the history here, what is the evidence about whether there is actual control over those documents in the possession of others in the corporate family. For example, this often comes up in the case of documents that belong to a foreign subsidiary, for example, where the parent corporation is the party to the litigation. It's generally held that a parent corporation has the ability to control its subsidiary. So any documents or information that are in the possession of a subsidiary are, in effect, in the possession, custody, or control of a foreign subsidiary, and the parent corporation can be required to get those documents and produce them in litigation. A more difficult question arises where the party to the litigation is a subsidiary. Does the subsidiary have possession or control of documents in the possession of the parent? Well, generally not. I mean, generally subsidiaries don't control parent corporations and don't have the ability to get access to documents, but there will be some times when the history may be and the record may show that a subsidiary could have access to documents in the possession of a parent corporation. In those circumstances, they can be required to be produced. Similar questions arise in connection with sister corporations that are under common ownership, two different subsidiaries. If this subsidiary is a party, a defendant in the case in the U.S., and this is a foreign subsidiary in another country, can this subsidiary be required to get the documents and produce them? Generally, no, the law says. But again, it becomes a factual determination under the circumstances. Let me talk now about the third subject. That is the use of discovery in the U.S. in aid of foreign proceedings. There is a section of the United States Code, Section 1782, which gives U.S. courts surprising and remarkable power. And this law provides that a U.S. court may order discovery to be collected and provided in aid of a case pending in a foreign jurisdiction. When there is not a case pending, even there is not a case, the case isn't pending in the U.S., the case may be pending in France or Japan or some other country, the court can apply, the foreign court can apply to the U.S. court for the U.S. court to require the parties to permit U.S.-style discovery, exchange of documents, depositions, the full scope of U.S. Discovery tools, to assemble information to aid that in aid of that foreign proceeding. In other words, to marshal and collect evidence that might be used in a foreign proceeding. But this doesn't apply only when a foreign court applies for such assistance. Under this provision, a party itself may go to a U.S. court and say, we're a party to this foreign litigation. We can't, under the discovery systems of that other country, we can't get access to this evidence. We would like you, the U.S. court, to order the production of that evidence here in the U.S. so that we can use it in the foreign proceeding. That's a really remarkable power. And the case law indicates that the court decisions have indicated that even if the discovery, U.S.-style discovery, is not available in the foreign jurisdiction, a U.S. court has the ability to require that discovery go forward in the U.S. to assemble that evidence. It's discretionary with the court. The U.S. court is not required to do this, but it's potentially a very broad, ranging scope of relief to enable discovery in the U.S. of parties to assemble evidence that you could not get under the legal system of the foreign country. Again, as I indicated, it doesn't matter what the foreign forum's discovery rules are, the U.S. court can order this type of production. You've got the slide materials. I'm going to jump forward to the final topic here, and that is some thoughts about international coordination of multiple proceedings, tips, and strategy. As Wayne Alexander and Ryan Goldstein have said, we see it increasingly common that for major litigations, there will be parallel or related cases pending in other jurisdictions. So coordinating those proceedings becomes more and more important as we have this, as the world gets smaller, and as we have multiple proceedings and disputes arising in related disputes arising in different countries. This is perhaps, as Ryan Goldstein was saying, very, very common in the patent litigation world, intellectual property world. It seems that for any major technology intellectual property dispute these days, you will have disputes not just in one jurisdiction, but they break out in multiple jurisdictions. For example, we all know from public information the disputes between Apple and all the other, the manufacturers and sellers of Android-powered smartphones. I don't know how many cases there are. Just to look at Apple versus Samsung, I don't know how many cases there are pending now in different countries around the world. There are numerous such cases. And these types of situations pose, I think, particular challenges to the clients and for the lawyers. Coordination becomes very, very important because you have to assume that any position that a party takes in any case, in any jurisdiction, in one jurisdiction, is ultimately going to be known in other jurisdictions. You can't tell one court in one country one thing and then tell another court in another country something different. You have to be consistent. You have to assume that ultimately that information is going to get out, and it's going to be the lawyers, your adversaries, if you contradict yourselves, they're going to make sure that the courts know that different positions have been taken. And this makes given that you have different legal systems with different procedural rules, different substantive law rules, and different lawyers running those cases in the different jurisdictions, this can be a real challenge. And effectively coordinating those multiple litigations may really be the difference between ultimately winning or losing, or the type of settlement or resolution that is ultimately achieved. And in our experience, it's very important that someone be in charge, and someone be designated to be in charge, someone be designated to be lead counsel, and that all the members of the team, all the lawyers in the different jurisdictions know who's in charge. Lawyers don't like vacuums. Lawyers will, if they're not given direction, in most jurisdictions can operate independently and not necessarily coordinate. Someone needs to be in charge, and everybody needs to know who that is. There needs to be an understanding of the different procedural and practical differences between the different jurisdictions.